What if the mother at the center of one of Ohio's most disturbing child neglect cases was not only an accused offender, but also a victim inside the same home? That question is now becoming impossible to ignore. Elizabeth Siders is the mother of the 16 children removed from a small house in Hamden, Ohio. She is charged with 16 counts of child endangerment, 1 count for each child. Her husband, Gary Siders Jr., and his parents, Gary Siders Sr. and Christina Siders, face the same number of charges. All 4 defendants have pleaded not guilty. None of the allegations against them have been proven in court. But Elizabeth's case has now taken a dramatic turn. Her attorney is not simply asking whether she is mentally capable of standing trial. He is also asking the court to examine whether a serious mental condition may have prevented her from understanding that her alleged actions were wrong. That raises a far more complicated question than whether the house was dirty or whether the children were neglected. Was Elizabeth an active participant in a system that allegedly kept 16 children isolated from the outside world? Was she a mother who failed to protect them? Or was she herself controlled, psychologically dependent, and trapped inside the same family structure? The answer could determine not only what happens in her criminal case, but also whether she ever has a legal relationship with her children again. On June 30th, 2026, investigators executed search warrants at the family's home on Omer Street in Hamden. Authorities said they found 16 children ranging in age from approximately 18 months to 18 years old. Officials described the conditions inside the home as deplorable and dangerous. Vinton County Sheriff Ryan Kane said a large number of the children appeared to have spent much of the previous 4 years in an area measuring roughly 12 feet by 12 feet. Ohio Attorney General Andy Wilson described what investigators reportedly found in extremely severe terms. Authorities allege that some children had difficulty speaking, that they lacked adequate education and medical care, and that the physical condition of the house created an immediate danger. Those descriptions quickly transformed the case into national news. Photographs said to have been taken inside the home later circulated online. They appeared to show damaged rooms, dirty bedding, writing on walls, and severe deterioration. However, law enforcement did not officially release those images. Their exact origin and the circumstances under which they were taken remain important questions. The defense has also challenged the language used by public officials. Elizabeth's attorney has argued that the children should not be described as feral. He has suggested that the conditions may reflect extreme poverty rather than a deliberate plan to torture or imprison children. That distinction will matter. Poverty alone is not a crime. Families can live in damaged homes, struggle financially, and lack basic resources without committing felony child endangerment. But poverty also does not automatically explain why children allegedly disappeared from school, received little medical attention, and remained largely invisible to neighbors and government agencies. The prosecution will have to prove more than the existence of a poor and overcrowded household. It will need to connect each defendant to conduct that placed the children in serious danger. Elizabeth's defense may now argue that her ability to make decisions was fundamentally different from that of the other adults. Elizabeth reportedly married Gary Siders Jr. when she was only 15 years old. She gave birth to her first child during the same year. From that point forward, pregnancy and motherhood appear to have defined nearly her entire adult life. She ultimately gave birth to 18 children. 2 conjoined twins died on the day they were born in 2022, leaving 16 surviving children at the center of the current case. By the time Elizabeth was arrested, she had spent almost 2 decades inside the Siders family. She entered that family not as an independent adult with an established career, education, and support system, but as a pregnant teenager. This does not prove that she was abused. It does not prove that she lacked free will, but it creates a background that investigators, mental health professionals, and jurors may have to examine carefully. Elizabeth's attorney, J. Thomas Stolley, says his concerns are based on more than speculation. According to his court filing, he met with Elizabeth several times and spent substantial periods speaking with her. During those meetings, he observed her behavior, demeanor, and ability to understand what was happening. The attorney told the court that those interactions led him to believe Elizabeth may have serious mental health problems. He suggested that her condition could interfere with her ability to understand the proceedings and assist in her own defense. That is the first legal question. Is Elizabeth competent to stand trial today? Competency is not a decision about guilt or innocence. A defendant can be mentally ill and still be competent. The issue is whether the person currently understands the nature and purpose of the legal proceedings and can communicate meaningfully with an attorney. Does Elizabeth understand the charges? Does she understand the possible consequences? Can she remember relevant events? Can she evaluate legal advice and help her attorney prepare a defense? If the answer is no because of a present mental condition, the criminal case could be paused while professionals attempt to restore her competency. That process could involve medication, therapy, and education about the court system. But the attorney's request goes further. If Elizabeth is found competent, he wants a separate evaluation of her mental condition at the time of the alleged offenses. This is the foundation for a possible not guilty by reason of insanity defense. Under Ohio law, that standard is difficult to meet. It is not enough to show that a defendant was depressed, traumatized, dependent, or living with a mental illness. The defense would generally need to establish that a severe mental disease or defect prevented the defendant from understanding the wrongfulness of the conduct at the time it occurred. That creates a major challenge for Elizabeth. The conditions described by authorities did not allegedly exist for a few minutes during a sudden psychological crisis. Investigators are examining a pattern that may have lasted for years. To succeed with an insanity defense, her attorneys may need to explain how a mental condition affected her understanding throughout the relevant period. They may also have to confront evidence suggesting that the family avoided outside attention. School records could become especially important. Court documents obtained by local journalists reportedly show that 6 of the children were enrolled in school at one point, but missed every school day for months. School officials attempted to address the absences. Truancy matters were reportedly initiated, but the family was difficult to locate or serve with legal papers. The family had also moved through several Ohio counties since 2008. The prosecution may argue that this pattern demonstrates awareness. If adults knew that school officials, medical professionals, or child welfare workers would question what was happening, avoiding those systems could suggest that they understood the situation was wrong. The defense could offer another interpretation. Frequent moving, missed appointments, and failure to respond to government agencies can also occur in families affected by extreme poverty, mental illness, fear of institutions, or domestic control. The same fact can support 2 completely different stories. That is what makes Elizabeth's position so complicated. Her brother, Jeremy Russell, has publicly claimed that Elizabeth was brainwashed by the Siders family. He has suggested that she believed she was caring for the children correctly and that she had become separated from her own relatives. He also indicated that he had gone many years without seeing his sister. These social media statements are not medical evidence. They have not been tested through testimony or cross-examination. Jeremy's version could be accurate, partly accurate, or influenced by his own emotions and family history, but his claims point toward a defense theory that may become central to the case. Coercive control does not always involve a locked door. A person can remain in a harmful environment because years of intimidation, dependency, and isolation have destroyed the belief that leaving is possible. The control may be financial. One person may control transportation, money, identification documents, and contact with relatives. It may be emotional. The victim may be repeatedly told that authorities will take the children, that outsiders are dangerous, or that survival is impossible without the family. It may also involve trauma bonding, in which fear, dependency, and occasional affection create a powerful psychological attachment to the person exercising control. From the outside, people often ask a simple question: why did she not leave? But leaving a controlling relationship is not always a single decision made by a completely free person. A woman who entered the family at 15, spent almost 20 years giving birth and caring for children, lacked independent income, and became separated from outside support could experience the world very differently. Again, this is only a possible explanation. No court-appointed expert has publicly concluded that Elizabeth experienced coercive control. No verified evidence currently proves that Gary Jr. or his parents forced her to remain in the home. The theory must be investigated, not assumed. There is also an uncomfortable truth that the defense cannot avoid. A person can be a victim and still harm other people. Trauma does not automatically erase responsibility. Even if Elizabeth was manipulated by her husband or his parents, she was still the mother of the children. Prosecutors will argue that she had a legal and moral duty to provide food, sanitation, education, medical care, and protection. They may ask whether she ever contacted a teacher, doctor, neighbor, police officer, church, social worker, or family member. They may ask who enrolled some of the older children in school. They may ask who later removed them from that system. They may examine phone records, online activity, benefit applications, transportation history, and every occasion on which Elizabeth was outside the home. Each moment of contact with the outside world could become evidence. The prosecution may say those moments represented opportunities to seek help. The defense may respond that a psychologically controlled person does not necessarily recognize an opportunity in the same way an outsider does. Elizabeth's own view of her situation may also be important. Her attorney previously suggested that she did not consider herself a victim. At first, that might appear to weaken the theory that she was abused. But victims of long-term control do not always identify the behavior as abuse. If a person entered the relationship as a child and spent her entire adult life within the same system, abnormal conditions may have become normal to her. She may genuinely believe that the family was protecting the children. She may distrust government institutions. She may not understand why others view the living conditions as dangerous. That could explain why her attorney became concerned after speaking with her. Perhaps she appeared confused about the charges. Perhaps she could not connect the alleged conditions with the possibility of criminal responsibility. Perhaps she showed signs of a serious psychiatric disorder. Or perhaps the competency request is simply a responsible legal step in an extraordinary case. Defense attorneys have an ethical duty to raise competency concerns when they believe a client may not understand the proceedings. The request itself is not proof that Elizabeth is incompetent. It is also not proof that she was legally insane. An examiner may find that she has mental health problems but remains fully capable of standing trial. That finding would not be unusual. Mental illness, legal competency, and criminal responsibility are three different concepts. Someone can have a serious diagnosis and still understand the court process. Someone can be competent today but claim that a severe disorder affected the person's understanding years earlier. Someone can also be traumatized and manipulated without meeting Ohio's narrow legal definition of insanity. Even if an insanity defense fails, evidence of control and trauma could still matter. It could influence negotiations between prosecutors and the defense. It could help determine whether Elizabeth receives the same treatment as the other defendants. It could also become a mitigating factor if she is convicted and later sentenced. Prosecutors might eventually conclude that she participated in the neglect but had less authority within the household. They could argue that Gary Jr. or his parents controlled the major decisions. Alternatively, the evidence could show that Elizabeth had an equal or leading role. At this stage, the public does not know. That uncertainty is exactly why the investigation must examine the family structure instead of treating all four adults as identical. Who controlled the money? Who decided where the family lived? Who prevented the children from attending school? Who communicated with government agencies? Who disciplined the children? Who purchased food and medication? Who had access to vehicles and telephones? Who decided whether outsiders could enter the home? Those questions may reveal where the real power existed. The fate of the children is now being decided in a separate but connected process. They have been placed in government care, and Vinton County has faced enormous financial and logistical pressure in finding safe placements for 16 siblings with potentially complex medical, developmental, and emotional needs. The county's annual cost of caring for them could reach hundreds of thousands of dollars. Ohio officials have considered emergency funding to help the county manage the situation. Authorities have said their priority is the physical, mental, and emotional safety of the children. The state may also seek permanent custody. Permanent custody would be far more serious than a temporary separation during the criminal investigation. It could terminate Elizabeth's parental rights and eventually allow some of the children to be adopted. That means Elizabeth may face two losses at the same time. She could lose her freedom in criminal court and lose her legal status as a mother in juvenile court. Even if she is eventually viewed as a victim, the standard in a custody case focuses on the best interests and safety of the children. A finding that Elizabeth was controlled might explain her conduct, but it would not automatically prove that she can safely parent 16 children. She would likely need to demonstrate independence, psychological stability, insight into what happened, and the ability to protect the children from the environment they allegedly endured. The court would also have to consider how the children view their parents. Some may feel attachment and loyalty. Some may feel fear. Some may have been taught that outsiders were dangerous. Others may be too young or developmentally limited to explain what happened. Their recovery could take years. The most important evidence may ultimately come not from dramatic photographs or angry public statements, but from medical assessments, school records, forensic interviews, and the children's developmental histories. Those records could show whether the alleged isolation caused lasting harm. They could also help establish when the neglect began and which adults knew about it. Public anger in this case is understandable. The allegations involve 16 children who depended completely on the adults around them. But outrage cannot replace evidence. Calling Elizabeth a monster before trial ignores the possibility that she entered the family as a vulnerable child and spent years under control. Calling her only a victim ignores the suffering of the children and the responsibility she may have carried as their mother. The truth may not fit comfortably into either category. Elizabeth Siders may have been victimized. She may also have failed her children. Both could be true at the same time. The legal system must now determine how much freedom she had, how much authority she exercised, and whether a mental condition prevented her from understanding what was happening. The competency evaluation will answer only whether she can participate in the case now. A possible insanity evaluation will examine whether she understood the wrongfulness of her conduct then. Neither evaluation will answer the deepest moral question. When someone has been controlled for most of her life, at what point does victimhood end and responsibility begin? And if Elizabeth was trapped inside the same system as her children, why were the children the ones left with no way out?